My favorite closeted soft sit is in court or was in court today, and I figured I'd go over it with you to give everybody some insight beyond what Mr. Freeman is telling you about what happened today. So he was indeed arrested 3 years ago. He was seen by a magistrate judge 3 years ago. That magistrate judge set him for a $1,500 bond set by Judge Sheed, Dorothy Sheed. She's a magistrate judge, same Dorothy Sheed right there. What happened between 2015 and today? I don't know. I can't tell you. The charge is online harassment web page. That's this 3307 here. A person commits an offense of the person without obtaining the other person's consent and with the intent to harm, defraud, intimidate, or threaten any other person, uses the name or persona of another person to create a web page on a commercial social networking site or other internet website, or post or send one or more messages on or through a commercial social networking site or other internet website other than on or through an electronic email program or message board program. Now, just so we're all clear at this point, do I know if he did it? No, I don't. Do I believe he did it? I have no beliefs one way or the other. I don't care. I'm just walking you through it. Uh, the date that this was claimed to have happened was 5/17/2015, so it was before he was arrested for it. It is a Class 3 felony, and nobody has moved to reduce it. There is no misdemeanor reduction. So, yeah. Somewhere around 4/20/18, the grand jury heard it. Why they heard it, I don't know. You don't know. And James doesn't know. His story about a police officer sending it up to the district attorney or something like that because James started activism is questionable at best. The grand jury returned a true bill on 4/23 of 2018. A true bill means that they said yes, there is probable cause to charge him with the crime or crimes. I don't know from this page if there was more than one offense. This may be just the most serious. There may be multiple of the same type. I don't know. Couldn't tell you how they do it in Texas. So, what do we know? We know that despite assertions otherwise, David Woodruff is Mr. Freeman's attorney. David Woodruff is a member of the bar. He's in private practice. He was not court appointed. This is David Woodruff. This is his bar number, same bar number. And he is in private law practice. And the phone number is 6474 and 6474. Look, it's a match. So we know that David Woodruff is his lawyer, and he apparently chose his own lawyer. There you go. Opposing counsel. This is the prosecutor, the district attorney of some sort. R. Watson. No idea about that. So, oh yeah, and then this hearing was his first hearing. 5/23/18. That's today at 9:30 a.m. It was his first hearing. Your first hearing, your arraignment. Typically, what goes on there is you go into court. The judge says, "All right, these are the charges against you. These are the potential penalties you face from these charges. How would you like to plead? Do you have an attorney? Do you need the court to appoint an attorney for you?" And then she'll ask the prosecutor, do you have any recommendations about bail? And then your attorney can be like, I think bail should be lowered, or there's no need for bail. And then the judge determines what your bail amount's going to be. And then they set your next court appearance. Well, his next court appearance is on the 6th. He might not have to be there. It looks like an announcement docket, so it's going to be something like his attorneys will get together and like determine what kinds of discovery needs to go on. The prosecutor will probably let his attorney know like any exculpatory evidence that there may be, et cetera, et cetera. They might get together to figure out when like the trial should start, figure out how much time each side's going to need to prepare, all that fun stuff. So at neither of these trials or court appearances is there any is it in neither of them will there be motions made, like say for example motions to dismiss or any other motions. There won't be any cross-examination going on. There won't be any evidence being passed or anything like that or being shown. There won't be any cross-examining of witnesses. The defendant won't be able to ask the prosecutor any questions. Just, oh my God, they wouldn't let me talk to the prosecutor. You're right, dummy. They won't let you. Can't talk to the prosecutor. Your attorney's supposed to be talking to the prosecutor. You have representation. The prosecutor is not supposed to talk to you. He's supposed to talk to your attorney because you're going to say stupid things. You're going to say stupid things like you're going to admit on a live stream that's disseminated. Oh yeah, this guy is a sovereign citizen and he's putting out stupid sovereign citizen cases. But you're admitting on a live stream that you recorded the court session. Imagine that. Imagine that. Imagine being so stupid that after your arraignment, you go on a live stream to tell the world that you recorded your arraignment in violation of the judge's orders. Explain to me what you're thinking when you do that. Christ on a cracker, sir. You are retarded. Anyway, so speaking of sovereign citizen stupidness, Havens v. Levine is actually Hagens v. Levine. And no, it doesn't say that. This is Hagens v. Levine. And at 533 is a very short page right there. It doesn't say anything at all about once jurisdiction is challenged, it must be proven. It doesn't say that at all. And in fact, Hagens v. Levine is a civil lawsuit. So, yeah, Mr. Freeman is facing criminal charges. Not federal lawsuits, but state criminal charges. And then the Standard v. Olson, no idea what that is. This is Olson. This is the Supreme Court's website. This is the actual supremecourt.gov. And they don't have State v. Olson or Standard v. Olson, nor do they have Standard v. Olson. There's 2 pages. There's page 1. There's no Standard v. Olson. There's page 2. No Standard v. Olson. Never trust sovereign citizens, and be very wary of people who boil an entire case down to a single sentence that contains a bright line rule. No sanction can be opposed absent proof of jurisdiction. That is a bright line rule. Be very wary of those. Always inspect what you expect. And police officers, U.S. Marshals, can ignore your no trespassing sign to walk up to your front door and knock on it for official business. If they are on duty, if they're acting in their official capacities as U.S. Marshals, there is no DA in the world who's going to bring charges against them. And in fact, there was a Supreme Court case. I don't remember it right now. some Florida case. Scalia wrote it. It was like 2013. Some Florida case. I remember the details of the case. A cop, suspecting that it was a drug house, a cop walked up to the front door with his drug dog, and his drug dog reacted to the smell of the pot grown inside. And Scalia, in his decision, said that there's implied consent to allow people to come up to your front door and ring your bell or knock on your door, even if you have no trespassing signs, etc. I don't think he said even if you have no trespassing signs, but there's implied consent. And so, especially if the police are acting in their official business, or if they're like if they're chasing somebody like into your backyard, like they're in pursuit of a suspected burglar or something, and that burglar ignores your no trespassing sign and jumps into your backyard, the police can follow him in there. There's absolutely no reason to believe the police need a warrant at that point. I mean, whether or not you think they should is up to you, but yeah. That's a good question. Denise Stark asked him, I've been watching all of this unfold. Where's your lawyer? His lawyer is probably shitting a brick. What's his name? Mr. Woodruff is probably shitting a brick, thinking about how retarded his client is acting and how difficult his client is making the case for him. Because arguing with the judge and being argumentative and et cetera, it's just not going to get you very far. I mean, the judge is probably a professional. I'm going to assume the judge is a professional, and the judge will have some level of tolerance for shenanigans, especially if the judge has been practicing for a while. If you're dealing with felons all day long, then you probably have had to deal with shenanigans a time or two. But James certainly isn't going to make it easy on his attorney, and he's not going to give himself the best opportunity for a full and fair hearing when he actually gets to the point where it's supposed to be a full and fair hearing and not an arraignment. Anyway, I hope I've enlightened you as to what's going on. Mr. Freeman probably should stop making live streams, especially when he's saying that he's violating court rules in them. Please, Mr. Freeman, if you watch this, please delete these videos, and please don't post videos from inside the courtroom, at least until after the trial. But hey, if you don't believe me, talk to your attorney about it. He may be able to give you some good legal advice in that direction. Have a great day.